The draft notification for the Environment Impact Assessment 2020 has drawn a lot of controversy. It is essentially a proposal to how permissions will be given to new industries to make sure that they don't pollute the environment any further. Now, it has drawn its own share of consternation from opposition leaders ranging from Sonia Gandhi to the Chief Minister of Kerala to the Environment Minister of Maharashtra, Aditya Thackeray. On the other hand, 17 lakh people have responded to the draft online as well. It will now go through its processes. The Union Environment Minister Prakash Javadekar says that this is only the first draft. There could be changes up ahead, and a committee will now sit on the changes that have been proposed. But it's very important to focus on what exactly it is in this draft notification that is irking environmentalists. Now, this is a very important and crucial issue for India, which is hoping to increase manufacturing, boost the economy, create more jobs and employment on one hand, and on the other hand is already grappling with the downsides of being heavily polluted as well as climate change. We're seeing it all around us. The eternal debate has been on how to strike a balance, and government policy plays a very, very crucial role in this. So to help us take a deep dive into what exactly are the contentious points in the EIA 2020, the draft notification, I'm joined today by Manoj Mishra and Shibani Ghosh. Manoj Mishra, of course, is the convener of the Yamuna GA Abhiyan, and Shibani Ghosh is a public interest lawyer and a fellow at CPR. Welcome to both of you, and great to speak with you on the show this evening. Mr. Mishra, let's lay it out for our viewers very simply, because not everyone has followed the story in great detail. To your mind, what is the real problem with the draft notification for the EIA, that's the Environment Impact Assessment 2020?
You see, this is not the first time that a notification of this kind has been made. This only tries to kind of revisit and amend an existing EIA notification, which is EIA notification 2006. And there have been infirmities with that notification as well. Now, what this notification does is, rather than address those infirmities and make that notification more environment friendly, this is trying to dilute even whatever was available for environment protection under the EIA notification 2006. Now, what this has tried to do, I think the very basic philosophy of this change that they are trying to make is against the very principles of the Environment Protection Act, which is the parent act for a notification like this, which says that the state shall protect and improve the environment. Now, what they are trying to do here, and as I said, it is their basic philosophy seems to be to promote ease of doing business. Now, no one is against ease of doing business. No one is against an economic activity. But we today, as we are living through a worldwide COVID pandemic, we have to understand that environmental stability, environmental protection, environment is the very basis of economic activity. So there is no, and if the environment is good, economic activity will thrive. So what is fundamental is that
I think there's no debate there. There's no debate there. In India has publicly stated that it wants to work towards stopping climate change or reducing the pace of climate change. This is our stated goal.
Publicly.
I want to know the specifics of what the problem is. So let me come to Shibani Ghosh. Let me come to Shibani Ghosh and keep the conversation moving. Ms. Ghosh, what is the problem? with this particular draft? What is in it that makes people think that this will harm the environment at the cost of ease of doing business?
Right. I mean, Mishra ji, of course, mentioned one of the big problems with it, that it does not actually conform with the parent law that it's been issued under. So some of the specific examples I could give, for instance, the level of scrutiny for some of the projects has reduced drastically. Some of the projects which were considered category A under the earlier notification and therefore would have got the highest category of scrutiny have now been, in a sense, demoted and will get either lower quality of scrutiny or no scrutiny at all. And there's also now a new category of projects which require what's now being called a prior environmental permission, which in some cases will really just be a letter along with an environmental management plan. They don't even require an environmental impact assessment for those category of projects. The other very big problem that this notification proposes is what it calls an ex post facto environment clearance process, which basically means that projects which should have got an environment clearance before they began operation or construction, and are therefore illegal when they have started construction, can now actually initiate a process by which they can be regularized and be given an ex post facto environmental clearance. Now, that's entirely illegal. The Supreme Court in at least 2 judgments recently has said that ex post facto environment clearance flies in the face of environmental jurisprudence. And this EI notification proposes to do exactly that. It's basically some form of an amnesty scheme with no cutoff date, which is extremely problematic because it really allows violators to believe that they can be, let free with a bit of a slap on their wrist. The other few problems, and you just mentioned climate change yourself, if you look at the notification, there's hardly any mention of climate change. I mean, if in this era, in 2020, issuing a regulation which doesn't have any consideration of climate change impacts, climate change causes of climate change, I mean, it is extremely worrying. We're going to be locking in carbon intensive infrastructure without proper scrutiny. We are going to be creating areas which should be, which are extremely vulnerable. We are going to be reducing their adaptive capacity through allowing projects to come up there. And another very big area of concern, which many people have pointed out, is the reduction in the scope of public consultation before a project is permitted. So, I mean, these are kind of 3-4 areas among many which are of serious concern with the draft notification.
The broad points. So I'm going to come in just a bit to the whole development versus, environment debate. And Mr. Mishra, let me pick off from there. Our stated position everywhere, from the United Nations to every international forum, is that we are for cutting down carbon emissions, we are for a greener environment and a better balance between the two. This is merely a draft notification. Now, if you see the statement of the Minister Prakash Javadekar, he says this is the first round of consultations and then we will take on board all the suggestions that have come in. Are you still concerned that there will be a sort of push towards easier permissions, easier compliance, which will end up harming the environment?
Certainly. You see, talk is one thing and walking the talk is another. They talk a lot all over, but what they do on ground within the country is very different. You see, there is a serious systemic problem with this notification, where the project proponent is supposed to commission an EIA report, a EIA consultant. Now, this very provision creates some kind of a collusion of interest between the project proponent and the EIA consultant. And this actually results in extremely poor, compromised, cut and paste EIA report. And the EIA report is the very basis of EIA notification. So if the very EIA report is poor, the entire scrutiny or whatever result from that is going to be very harmful for the environment. So rather address this interest, this collusion of interest, they have allowed to keep this going. And what they have done, which Shivani ji has also mentioned, is that they have taken away some extremely environment harming activities away from EIA reporting whatsoever. So, and then this whole thing about the post facto clearance mechanism that they are introducing in this very notification. This did not exist in EIA 2006 or in EIA 1994. It is something new.
Right.
And the Honorable Minister has gone on record several times saying that whatever we are doing is for ease of doing business. You see, we want to ask just one question. Every other ministry in the union is for ease of doing business. There is only one ministry, which is the Ministry of Environment and Forest, which is supposed to take care of, under their constitutional mandate, to protect the environment and improve the environment. Now, if even this ministry actually falls in line, who is going to protect the environment? Does other ministries say that we are also for ease of protecting the environment? No one says that. It is only this ministry that has to say that, and even this is now
binary,
not
though?
saying.
Sure. Is it a binary though, Ms. Shivani? This is really the crux of the debate. Is it an either or situation? Because the sad and sorry fact is that earlier very stringent provisions on paper to protect the environment neither protected the environment nor did they let any business grow. So does it have to be a situation where more stringent rules on paper come in, or is implementation the key?
I think the problem is both in terms of the letter of the law as well as the implementation of the law. I do not think we should be under any illusion that the existing law was very stringent. It was certainly better than what the existing proposed law, what the proposal is. But I would not call it, I mean, there must be a section of the society which would call it stringent, but as far as protecting the environment was concerned, I don't think it was stringent enough at all. Whether it was protecting the environment or trying to hear the voices of the people, the vulnerable groups who would be directly affected by the proposed projects, I think even the law on paper was not stringent enough. Just the quality of scrutiny, the quality of independent appraisal, the manner in which the public consultation and the views of the people were actually incorporated or at all responded to was just not adequate. And I think this is this opportunity of changing the law is an excellent opportunity for the government to overhaul and reform the process. But the goals have to be very clearly improved environmental outcomes. And in that process, if we can also have good business and a good economy, that's excellent. Why not? But really, ease of doing business at extremely high social and environmental costs is what I think we are going down for, and I think that is unacceptable.
Okay. What do you hope to see next, Ms. Shivani? Now, this process is a consultative process. There has been a lot of opinion coming to the fore, huge responses online as well, despite a COVID pandemic, etc. You have prominent opposition leaders coming out and speaking about it. What do you hope to happen next?
So this public consultation, let's be clear, is statutorily mandated. I mean, it is not something that the government chose to do. It is required by the Environment Protection Act that if such a notification comes out, the government has to give public time, right? So that's what the government has done. And as the statutory process goes, the government is required again by law to consider the suggestions that has come to it and then to respond to it in a proper fashion. Now, what would happen next? I can't say how the government will deal with the lacks of representations and concerns and appeals that it has received. But I certainly do hope that the government will not be hastily making any decision, because something like this has immense ramifications, which are often irreversible and will go on for a very, very long time in future. And therefore, I think the government would be well advised to slow down this particular legislative process, take into consideration the comments that have been sent, perhaps undertake further consultation, not through this process, but maybe stakeholder groups. I believe they've reached out to industry groups, but they could also reach out to other civil society groups which have been working in this area for decades. They could reach out to them to understand their concerns better. Because, I mean, if we hastily put in a law right now, the impact of that, I don't think we can even foresee at this level, at this stage, and it would be remarkably, staggeringly high cost for the society as well as for the environment. So I don't think the government should go ahead with this at all and should not be in any hurry. And just as a last point, the government does actually have a lot of time in hand. It has itself recently amended the environment protection rules, which allow it to consider keep a draft notification in that stage for, I believe, more than 700 days, 725 days. So there is no reason for the government to, act in haste at all right now to issue the final notification, and it can come up with another draft. Work on this further.
Well, I think
it has several options.
Yes. Important to remember a few things. This is yet a draft. There are a lot of, suggestions which have come in, a lot of opposition to the current version of it. And there is a stated purpose to protect the environment. Now, whether it's being done or not is a different story. It hasn't been done so far. I think also important to emphasize that this is not an issue that we can skirt over. If we absolutely have to choose between protecting the environment from degenerating further and ease of doing business, well, the environment will win. The last year has shown us that it is a price that we cannot afford to pay. I want to thank both of you, Mr. Mishra and Shubhani, for joining us on the discussion this evening.